Thank you so much for being here to identify yourself for the record and what you.
Thank you for having me. My name's Meg Yor. I use she, her pronouns, and I'm here on behalf of Family Equality. I'm the director of LGBTQ Family Law and Policy and Senior Policy Council, a little bit of a mouthful, for Family Equality, which is a national nonprofit advocating for lived and legal equality for LGBTQ families. I am also a Vermont attorney, and so I'm a Vermont attorney. Live here in Montpelier, and prior to joining Family Equality, my work really focused on family law work. I was the lead attorney of Vermont Law School's Family Law Clinic, along with Michelle Donnelly for a while, and we did a lot of family law work through the clinic. I also have done family law private practice and represented families in the child abuse and neglect dockets here in Vermont. I'm also a mom who created my family through assisted reproduction. And so I tell you all of those things because each of those aspects really plays a role in why I feel, why I want to talk to you today and how I see this bill and why I think it's so important for Vermont families and particularly for Vermont children. So in my role with the national nonprofit, I can see how important state protections are for families who travel, for families who move, and how critical those protections are, particularly for kids, right? Because the kids don't have a say in whether or not a state recognizes who their parents are, but they can feel the impact when those parents are not recognized. They're the ones who can really suffer in this process. And so Vermont, has done a lot of work to really be ahead of the game, as Polly was talking about, a leader in some of our parentage work, to make sure that children who are born of assisted reproduction are really protected and that their families are recognized, their parent-child relationships are recognized under state law. But when these families travel, when they move, we want to make sure that Vermont children are protected no matter where they are. And that's one of the things that this bill really does, is that it results in an adoption order, which other states must recognize, even if they wouldn't do the same thing themselves. And so I think that is a critical point of distinction here. And one of the things that really matters for Vermont families. Vermont is lovely. Vermont protects us. Other states have other states are doing things differently. I will also say that as somebody who has practiced family law here in Vermont, I've seen how clunky the step-parent adoption process is for families created through assisted reproduction. And that, of course it is, right? Of course, because it wasn't designed with these families in mind. We had the step-parent adoption process was really put in place to say, hey, there are circumstances where adoption doesn't have to result in a termination of somebody's rights because we've got somebody who's there, who's parenting, and they're bringing somebody else in. So that's kind of why we have this step-parent adoption process. And then in 1993, we had the BLVB case here in Vermont. And in that case, there was a lesbian couple who was like, we can't be married, but this is our scenario too. And so the court was like, hey, let's look at what the intention is here. And the intention is to preserve the family unit and to keep it intact. And so we'll use that step-parent adoption framework for this family, even though they're not married. So then in, I think it was 95 or 96, we had the Adoption Act that said we're going to put in or partner of a parent as somebody who can also utilize this step-parent adoption process. And the result of that has been that all of these types of families kind of filter through the step-parent adoption process when they're wanting to get an adoption. On the Judiciary's website, where you see the forms for step-parent adoption, you'll see step-parent/partner adoption, right? So they're all kind of lumped into the same thing. But even though we've got these maybe more progressive words like partner, that doesn't mean a more progressive process for these families. You still have a system that really looks at these families through the lens of bringing a legal stranger in and establishing parentage. But as you heard Polly and Kurt say, for these families, they already are parents. And what they're looking for is that extra layer of protection. The process, not only is it kind of clunky and doesn't really fit, it's also really confusing for parents. There's a lot of forms. A lot of the terminology in the forms just doesn't feel like it fits with the family structure. You do sometimes have the waiver of the home study, but you've got to ask for that waiver. Sometimes you have to explain why you need that waiver. In my practice, there were judges who would say, sure, we'll do the waiver, but you need to send us letters of recommendation that you would be an okay parent instead, which is hard for parents who planfully created this family together. It's not just hard, but it's a little bit insulting. I mean, if I'm being really honest about it, there are people who are deterred from the process, not only because the process is onerous, not only because the process is lengthy, not only because the process is expensive, though it is all of those things, but also because the process is just taxing on these people who have worked so hard to build their families, worked so hard and planned so thoughtfully to create their families, and are now having to come to say, please recognize me for who I am. That is really hard. And it turns people away, right? It turns people away from something that could offer them a critical protection. And so we don't want to do that, right? We want to make, for these families who are so thoughtful, who work together to plan their families, we want to make sure that they have a streamlined process that they can access protections that will follow them no matter where they go. And that's what this bill does. And that's why it's so important. We do, as you've heard everybody say, we have that path to parentage through the parentage process, right? Through our Article 7 of our Parentage Act. People can do that, but that doesn't necessarily mean that they will do that. And this does provide them with another option. And in this day and age where people are concerned about protecting their families and they're not sure what they want to do, we have a streamlined path to adoption that gives them that order that they know is going to be held up. We have the Supreme Court case, VLVEL, that says other states have to recognize this, and that is super, super critical for these families. This has been an issue that I've cared very deeply about for quite a while. I actually wrote on this exact issue for the Vermont Bar Journal back in 2017 about this process and why it's so complicated. And interestingly, the Vermont Bar Journal, maybe not interestingly, but they put this article in the Children's Corner section. And that's important because it really highlights the fact that these types of bills and these types of laws really protect the children. Right. And that's what we're looking to do, is we're looking to protect the families and protect the children who are created through assisted reproduction. So I'm really excited actually about this bill. I think that it is, in my opinion, an easy yes, because we're not expanding the law, right? We're not changing who's recognized as parents here in Vermont. All we're doing is saying, we're going to give you that path to security, to comfort, to the ability to travel, to with knowing that your family is protected. And we can do that so easily. It's not going to expand what the court has to do, because these parents could be seeking parentage judgments under Article 7, also through probate court. So we're kind of having a streamlined process. These people aren't going to do double orders. It's one or the other, and it's just a simple path right there through the probate court. As Rep. Richardson mentioned earlier too, we're freeing up resources for the families that do need that intervention, that the court does need to look into their family and get a little bit more information, because we're not taking up all that time for these families who are created together. So I think that this bill really provides that mechanism that we're looking for to streamline the process and confirm. I love that the word confirmatory is in here, because it confirms what the parents of these children know already, that they are the parents. And so I think that this is super important. Other states are doing it. We've got 8 other states already, more this legislative session. I think this is a great bill for families, not just LGBTQ families. Of course, you know, my organization serves LGBTQ families, but for all families who use assisted reproduction, where there's that potential lack of genetic connection between a child and their parents. This firms up those legal connections for all of those families. So super supportive of this bill. Happy to answer some of the questions that have come up before, and if new questions arise, happy to talk about those as well.
Questions? Barbara?
So in some of the other states that you've worked with, have there been people that have had concerns that we should be prepared to address? And if so, what kind of concerns do people have?
Well, I think, I think it depends on what you're talking about with concerns. The questions about whether or not to include surrogacy have come up in discussions in a few different areas. And the consensus, again, like I said, that's a policy decision. You can decide to do what you want. The consensus has been that the Parentage Act and our Vermont Parentage Act in 15C in Chapter 8 really talks about all of the requirements needed to do surrogacy and has a lot of protections for the surrogate and the intended parents in that process. And so part of, I think, the consideration to not include surrogacy in confirmatory adoption is you don't want to inadvertently create an avenue for people to go around those protections that the legislature so thoughtfully put in place.
So
Before you ask that, just how would they go around that? I'm sorry, Barbara, but I'm just.
Well, I think, I don't know necessarily that they would, but I think in this idea of if you are an intended parent, of course, the surrogacy, you go through the court and you get a judgment. But for the families that did not follow the typical surrogacy process, the surrogate didn't have that surrogacy agreement, look at it in great detail to determine how everything was complied with, and if it was substantially complied with, all of those types of things. And so if you had a family per se that didn't comply with all of the things and then they come through confirmatory adoption, you just don't want to create a situation where we don't have those eyes on the process and people could avoid it. I don't think that would be a large problem. And we do have that kind of hatch, if you will, in the confirmatory adoption bill that does allow a court to come in and say, hey, wait a minute, we're going to do more examination here. So, that is something that you all could consider in conversations. That's been one of the justifications for not including that provision. Plus, as Polly talked about, these families already have court orders, and we're not saying that an adoption order is stronger than a parentage judgment. In our minds as lawyers, it's not, right? They should all be entitled to full faith and credit. These should hold up. And at the end of the day, too, we know that people want options, and this feels like a good option to present to families who were created thoughtfully together.
Yeah, go ahead.
Yeah. So it's interesting because I've been trying to think about, especially if I get the opportunity to present the bill on the floor, like what will people ask for? And in working with families as a social worker, especially single parents at times, or young families, I've had well-meaning community members ask, like, why don't we require parents to do something before they become parents? I'm like, well, we don't. Mm-hmm. And in learning about this issue last biennium, through one of my colleagues and in conversations with all of you who are here today, it's like, wow, well, we're asking certain parents to do that, but not other parents to do that. And either we care about child safety and I can't even imagine going in the other direction, but that is what we're asking some people to do right now. And that just shocks me. But I just wondered if people have thrown like child safety in, which would be, again, like, not like these people are already parents. I get with a step parent, sometimes it's like, well, this step parent is actually on the offender registry, so they can't adopt, or there's some other concern. But it does feel, I'm going to say discriminatory currently, and definitely not respectful.
Yes, I think that I think it is very important not to exceptionalize families who rely on assisted reproduction to grow their families. Of course, if a circumstance came up with abuse, we have mechanisms for dealing with that, but we don't do that. Like you said, families are created, and families are created in all sorts of ways. Our laws reflect that already. And what we're saying here too, yes, is that these are families that are created intentionally. These are families that are created thoughtfully, and we are not going to treat them as exceptional under the law. We're going to recognize who they are and how their family came to be. So, yes.
Thanks.
So I saw Polly jump on screen. Did you want to comment on that as well, Polly? On that exchange?
I just want to say, I think it's really good to anticipate those things. Thank you for doing that. I have been involved with a number of, it's kind of like my life's work to figure out how to make children more secure and protected to their families. And with confirmatory adoption laws, I have not seen, honestly, a concern about these bills. I have not. The only concern, and I think I'm so glad the judge is here, is, once I heard a concern from a judge to make sure that courts still have discretion if they feel like they need some more information, right? And, I think this was drafted to allow for that discretion. So I have not heard or seen those concerns happening in other state legislatures.
Thank you. Okay. That's
Ian.
Thank you for being here. You heard us talking a little bit about providing for this avenue for other parents that, de facto parents or something like that. Do you have any thoughts on that discussion to advise the committee?
Yeah, I think, de facto parentage, I'm really glad that we have that avenue here in Vermont. Not every state has an avenue to establish parentage through de facto parentage. But de facto parentage is bringing in somebody new. We're kind of looking back at that establishing parentage versus creating parentage. And here in Vermont, we have really rigorous standards for examining whether or not somebody is a parent under the de facto standard. So I think that adds an unnecessary layer of complication to this bill, because here this bill, what we're looking to do is confirm the people who thoughtfully, planfully created their families together to give them that extra layer of protection that they need for traveling. So my recommendation would not be to bring that into the bill. I think it just adds a layer of complication.
Thank you.
Mm-hmm.
Other questions for me? Don't see any. Thank you very much for being here.
Thank you so much. Really appreciate it. Thank you.
And we'll hear from Judge Zone. And thank you, Judge, for being here.
Thank you for having me. Tom Zone, Chief Superior Judge. Excuse me. So sitting here listening today, I'm reminded of a letter that was written in 1789 by George Washington to Edmund Randolph, the first Attorney General, when he was trying to set up the government and the judiciary branch in particular. And within his letter, he wrote that he was looking for the finest people, essentially, to come to work in the judiciary because the judiciary was responsible for stability and happiness in the country. And I often use that quote because I think it's very relevant and important for us in the judiciary to consider that. But I must confess that oftentimes I wonder the happiness part. You don't always see that. And as I'm sitting here today, I'm thinking, well, this is that kind of bill, isn't it? That he was thinking about. It adds stability, and it seems to add a level of happiness that we often don't have in the judicial system. The policy as to whether to adopt this type of bill is certainly one for the committee and the legislature. But it is clear that if you adopt a bill that accomplishes the goal that you are seeking to accomplish with this draft, that it would provide, use some words from Mr. Hughes, security for individuals. It would provide, from a judicial perspective, consistency across the courts. We've heard testimony today that there are different interpretations and different ways that judges do things. Now, certainly judges have discretion to operate within the law and utilize that discretion to accomplish and effect the administration of justice that they believe it should be done. But having a set of procedures and rules that are governing in all of our counties is always a good place to be. And finally, it brings stability, because right now individuals, yes, the parents have parentage for the state of Vermont, and this is not giving many of the parents anything they don't already have, but I've heard the expression belt and suspenders. And if that's the case, why not? Frankly, they're already allowed to do it. Individuals can already seek the second parent adoptions, the step parent. And so this process addresses a specific issue. And in going forward with that, as far as the impact on the courts already have the potential impact of the structure that doesn't fit well. As Mr. Hughes talked about, the forms don't necessarily work. You're trying to fit, we'll say, the round peg in the square hole. And in my assessment, what this does is this says, here's our issue, and we want to recognize that there should be special circumstances that a special procedure for this because we don't need to go through a procedure that really doesn't fit. I did hear questions about de facto parentage. If you added de facto parentage to this, it would significantly increase issues within the court, and the tension of cases in de facto parentage can often be quite high. There are just the word dispute, and I'll talk in a few moments about the word competing, and that certainly is a word that applies in de facto parentage cases. So if your goal is to provide the type of security, consistency, and stability for individuals involved in assisted reproduction, my suggestion would be that you consider addressing that now. And if down the road it comes up that you want to tackle de facto, address that in another session possibly. But for now, focus on what your goal is, and that is to help individuals who are affected here. When I look at the bill, it defines petitioners on page 2, line 8, as persons filing the petition. It then, on line 17, says one of the things that's required is a petition signed by all parties. The word parties is not defined. And so what does parties mean? Does parties mean parents? And if it means parents, it's a parent under Title 15C, Chapter 7. Is that what it means? And so you may wish to consider whether or not to identify what do you mean by the word parties there, because it would seem to certainly be different than the word parents if you're using different words. And if it means parents, say parent, and it should say parents and define that. On page 3 at the top is where the word competing first comes up. The petitioners would have to attest that there are no competing claims of parentage which exist. I'm not sure that the word competing is the best word to use, because competition, I think the dictionary definition of competing is that someone's trying to get something over someone else. And what you're really talking about here is, does someone else have a right or have a parental right that has been recognized under the law? And if I can just have you jump ahead to page 4, line 9. The finding the court has to make is that there are no competing claims of parentage, or that any other person with a claim to parentage of the child who is required to be provided notice or must consent has been notified or provided consent to the adoption. So the question that I have is, why would the structure be such that you have competing up top only for the person has to certify that there are no other competing claims, and yet down here, the court has to find actually a different standard? Where would that information come from? And so my suggestion would be that if the idea is to simply say that there's no other individual who's a parent under the law, then you may want to just come right out and say that, as opposed to saying competing and leaving it open. Because there could be someone who is a parent and the person goes, oh, they're not competing. I know they're a parent. They already have the order. So I will leave that to the drafters to work on, but I think it would be helpful to, again, as simple as attesting that there are no, if you were wedded to the word competing, claims of parentage exist or other parental rights, recognized or identified or ordered under, again, 15C, Chapter 7, I think, is where it happens. The issue of the donor. The court shall not require, under line 8 and 9 on the same page 3, court shall not require notice of the adoption to the donor or consent to the adoption by the donor. I think what is intended here is that Well, if a donor is not a parent. And so therefore, you don't have to notify someone, as Mr. Hughes was talking about, some judges apparently have required notification to the donor who is not a parent. But the difficulty I have with the language here is that under Chapter 7, Section 702, subsection B2, I believe, a donor can be a parent if they sign an agreement, and then that agreement is under 704, which makes them a 703 parent. I think I got that right, jumping around. But my point is that just because someone's a donor doesn't mean they might not be a parent. You can be a donor and under Vermont law, you can still be a parent. And so you may wish to look there and add language that says, unless the donor is a parent under 15 C VSA Chapter 7, to make it clear that if the donor is a parent, they are a different type of donor. They're not, they would need to be noticed. Under subsection F, it talked about the courts has to make written finding demonstrating good cause for a number of things. I understand the rationale as to why this particular type of process does not need the same type of process for an adoption, where I think one of the witnesses testified that it was, if you will, non-family members. Here, they're already family. The one issue that does come up in my mind is, and it was a question I think Chair Lalonde asked, and that had to do with, I think you used the word coercion and asked about that. There are times that a judge sitting in, I'll use divorce for an example, or a parentage action where you have individuals coming before you in a very emotional situation, where you can look out and you get the sense something's going on here. And something's not quite right. And it may be I'm not saying that a judge sits there and goes, oh, it's X, Y, or Z, but you have the ability to look at someone and say, has anyone forced you, Ms. Arsenault, to sign on this agreement? Have you had a chance to fully consider the circumstances of signing this? And do you wish to consult with legal counsel or anyone else about this? And are you comfortable going forward today? To let people have that opportunity to weigh in. It may be very, very, very infrequent. But if you start off from the prospect that you can't have in-person hearings or appearances, how does a judge ever possibly get to that if there's something that clues the judge in without saying, the court's concerned that Ms. Arsenault may be a victim of, and I think that could lead to problems where none exist. And so my suggestion would be that if you take out the language about not requiring an in-person hearing, you can replace it with that the court is not required to have a hearing on these matters and may grant it if it is satisfied on the filing paper, on the papers, something like that. That signals that we don't have to have a hearing on everything. But when you set that standard at good cause and you put that in, I think it does set up a somewhat of a tension. And we don't want that. We want, again, if the goal here is stability and to get to that happiness that people want, we don't want to add issues and make what could be a difficult situation worse. Because, again, our goal is to develop a process that is not, Mr. Hughes's words, taxing, and I think it was Ms. York's words, not insulting. That is certainly, when I hear that about the system that I'm working in, the judiciary, about the processes that we have, it does concern me that we do that, and we need to make sure we take steps to address it. And so I think that would get away from that. On page 4, I testified previously in this committee about anytime you put in a requirement for days on line 2, about how many days the judge has to do something. For those who are new, my question is, and what if it doesn't happen? Does that mean we grant it automatically or do we deny it? And so to have a timeline without a remedy, I don't advocate. I think it leads to a lack of consistency. And I think, quite frankly, it leads to a lack of respect. If you put something in and, well, we don't have to follow it, we're the court, and there's no remedy. If the judges should know that things absolutely need to move under this process in a very streamlined timeline. That this is not intended to be, as Mr. Hughes noted, for certain hearings, 3 months to get something back and forth. That's not the way it's supposed to work. And I will let the committee know if you were sitting here and you heard Mr. Hughes testify and there were some concerns you heard about, well, boy, it seems to be taking a long time. And it seems like some of the judges, if the law is pretty clear, why would they be doing X, Y, or Z? It has been noted. And it will be, I do not get involved in specific cases, but I will tell you that there are times that I hear testimony and that I get input from legislators or others, that I do send out emails or speak to judges as a whole and say, this has been an issue. This has been a concern. Just wanted to highlight this is the law. If anyone has any questions, let me know. Something like that, because I do think it's important that we address those.
So thank you. Super, super helpful. I'm wondering on your last comment about the memo, I know you don't have as much authority or control over the probate judges, so I'm just wondering how that works. You send them information and they.
So we've begun, last week, I meet with the superior judges and the trial judges once a month. We have now implemented that for the probate judges, and it's quarterly though. We had that last month for a quarterly meeting. There are some other issues that came up that I had suggested that we should meet again in the next several weeks. So I meet with the probate judges under the administrative orders. Probate judges come into the bench elected in their districts.
Right.
Once they're on the bench, they still fall within the Code of Judicial Conduct and the administrative authority of the Chief Superior Judge. The issues of rotation, moving them, and having a probate judge go between districts, that is different than a superior judge because they preside in their district. There are times it is necessary to have a probate judge assist in other areas, and they are able to work there. But it is different.
Right. And I was thinking about what we've heard from state attorneys or sheriffs about being elected and having not being subject to the other branches. So, yeah.
We are a unified court, and under our structure, the Supreme Court runs the court. They have the court administrator and the chief superior judge to help administer that. And there are administrative orders and the Code of Judicial Conduct, which puts all judicial officers as far as ethics and their obligations to do the job the right way in a place where I have the ability to work with them and hopefully impact their performance.
That's good to know. Thank you very much. And your comments are really, really helpful.
Karen's question, then I have a question as well, unless Karen has my question.
I don't know.
So this is also back to the 30 days, because I appreciate the stuff like, okay, so what happens if if it's not met? And so I hear that point, and I would see judicial retention as a way to look at this, but for probate, there isn't judicial retention. So I am concerned about the checks and balance piece of this, because the probate judges are elected. Like, there has to be some measure of it. So I'm hearing that point, and I guess I'm just trying to think about what are some other ways that we could do it, which I heard you say, like, you could bring it up and talk about it in these meetings, but I feel like if it was judicial retention was in place, we would be able to ask those questions, like, how often are you meeting your whatever it is?
The issue of timeliness of decisions. When I had the pleasure of being named Chief Superior Judge, we didn't have a policy, a written policy. There was an idea of, okay, you're supposed to have your decisions filed in a reasonable time and try to get them in within X period. We issued a written policy that says you're supposed to get them in at the outside within 90 days. But that doesn't mean you wait for 90 days for cases, because there are a lot of decisions and matters that need to be done sooner, and most are. Most judges don't get to that. When there are judges who are not, whether it's superior or probate, when there are judges who are not meeting their required timelines or are getting close and I'm concerned and they're falling behind, we have the ability, and I have the ability to specially assign another judge to go into dockets. I have in the past several years had times where we have taken a probate judge from one county and had them work in another county to assist because the probate judge in that county has not gotten things done at the level that is necessary and has fallen behind. And so that's a strategy too. There might not be the retention, but if a judge is getting to that point, I have the ability to put someone in to assist in that matter. I get that that still does not address what I could do with superior judges. I can also take probate. I've also had probate judges. Now I'm focusing on them because this happens for all judges, but I've also had circumstances where I have directed that a judge is not to sit, that you need to address some matters. You have a decision, let's say there's a 30-day timeline, you're on day 45, you are getting a timeout essentially. You're off the bench because you need to focus on getting these cases done. And so we have that type of ability with the judges, but there is no retention, as you point out. And so what happens is that is every 4 years, the electorate has to determine whether or not the probate judges are meeting the standards that the people in that community want them to meet and meeting the standards that we put forth in the court.
And I guess for me, that is the piece of maybe why it might be good to keep it, which I hear you saying, like it could cause frustration because there's no penalty for it. But I feel like it creates that benchmark or piece where we can evaluate if they're meeting that or not. If there's nothing there, it would be up to every person in your position to decide, oh, okay, are you meeting timeliness or not? And people might have a different definition of timeliness, where this creates some boundary of timeliness.
So on that, I mean, I think there's other ways we've approached this to give the court some more discretion, but also make clear our expectations and desires as far as timing. And I know in some other places we put in language and do you have any suggestion as far as keeping the prod, but having some discretion that, or I wouldn't say prod, expectation, but understanding that.
So let's say I'm a judge who doesn't, and I'm using this for hypothetical, this is not me. But let's say I'm a judge who doesn't like the idea that you're putting a timeline in here on this bill. The court shall grant the adoption under this section and issue an adoption decree within 30 days upon finding that. Okay. So when I get around to making that finding, I've got 30 days to issue my adoption order. You haven't put in a timeline for issuing the finding, right? Am I correct, Mr. Goodenow, the attorney? Right? It's not getting it. And so there's an issue there. So where does the 30 days, if it's upon the finding, if that's the measurement point, you still haven't tied in the finding to the filing date or any paper. And so if you want to, I suggest, the court shall grant the adoption under this section and issue an adoption decree promptly upon finding, things like that. And I can assure you that we in the judiciary will, on this type of bill, knowing what the intent is, highlight that for all judges.
Angela and Ian. That was the
I
order.
guess I wanted to make sure did you get all the way through the bill?
No.
Okay.
That's some more.
Okay, so let's go to Ian if he has a question about this.
No, I want to hear the rest of the.
Okay. What?
Then on line 9 for page 4,
Yeah.
I was back to the issue of there were no competing claims of parentage or that any other person with a claim to parentage who is required to be provided notice has been notified. A judge couldn't make that finding. If it's not part of the initial information that's coming to the court, how could we make that finding? Because we don't know who's supposed to be notified because no one's told us whether there's anybody else out there. And so I think the practitioners and drafters can, I'm sure, come up with some language to make sure that the due process rights of anyone who is a parent that they are notified. And one way you could do it is to even add on page 4, add some language, add a number 3 at 1, 2, 3. You could add a number 3 that says, if a donor has parental rights pursuant to or another court proceeding, the court must also find that they've relinquished that right or that the right remains preserved by agreement of the parties, or after hearing the court has terminated that right, but there's no process here to terminate that right. What this really seems to be is a situation, this bill, in my assessment, is that anyone who has a right to be a parent under the law, who is a parent under the law, agrees to this. Because if it's not, there's no standards for deciding, well, we're going to do this anyway if 2 out of the 3 individuals who are listed as parents under the 708 order, I think it is, under Chapter 7, if 2 out of 3 agree, then how do we decide? And so this, as I read it, is really for the cases where everyone's on the same page. And all we want to make sure of is that when we say everyone's on the same page, that it is everyone. And that there's no one else out there who could say, well, wait a minute, I'm a parent too, under the law. And finally, yes, having until September 1st gives us more time to get things done. But whatever day you choose, we will make it work. We have, this is the type of bill that we see it coming. If it passes the House, then it passes the Senate. I'm already on with working with the judges. I do a summary every judicial college at the beginning of June, and we would highlight for the judges, probate judges in particular, this bill is coming. The court clerk, the trial court operations, Lori Canty and her group would know this is coming. And so it would sound like Ms. York, Mr. Hughes, and others who work on forms, to the extent that forms need to be developed, that can all get going and go to the probate oversight committee for review. We can get things going in a way that can match it. If there's a need to get this done on July 1st, we can work. We'll make it work.
Angela, the need.
Okay, so this is, I've been waiting for this moment, because this goes back.
Oh, my goodness.
Goes back to the question I asked 2 hours ago. And you've answered it in parts, and I want to put it all together for myself. If anyone else is interested, that's great too. So it has to do with my original question is why do we have an attestation? So again, we're talking about the no competing claims of parentage existing. And I've heard you say that there's more we could do to clarify exactly what we mean there. But it seems odd to me to require an attestation as part of a complete petition, and then to say the court can find that or must find, because it's upon finding that, and it's one of them, there are no competing claims of parentage and all that other language. To me, an attestation means something, has to mean something. So is it common practice to say that you're going to attest to this, but then we're going to make sure because we don't believe you?
Think of it in the same area of, in the same way of a relief from abuse order. An individual who has been the victim of domestic violence contacts the court, and the elements that they have to establish are that they are a family or household member, that there is an immediate danger of further abuse, and that that there has been abuse, and that basically that the order is necessary. The application and the complaint form contains all of those boxes. And then you fill out the affidavit saying, here's what occurred. That's an attestation of this is what happened. That is necessary because when the judge looks at it, the legislature has said, well, in order to issue a relief from abuse order, you have to find A, B, C, and D. If we didn't have that attestation, if we didn't have that paperwork with all of those different components filled out, the judge couldn't make those findings after hours or at the hearing. The judge needs to get evidence. But that after hours one is, we could never do it because, well, how do we know they're a family or household member? They haven't attested. Here, The legislature, as I understand this bill, is saying, in order to grant this order, the court must find A, B, and C and to order the adoption. And what the bill sets out is that here is the way that we think the judge can make that finding. The judge can find A, B, and C because the petitioners gave it to them in the application. And so that's part of the streamlined process. And you're allowing, what you're basically saying is, Judge, if you have this, that's enough. And we are comfortable that that's enough for you to make this order. And it allows the party to, and I think there was a question asked before, could someone lie on that? Yes, but that's a risk we have in all areas. But as a practical matter, without that attestation, there'd be no ability of the court to ever order this because we couldn't make the findings that we need to.
Right. So the attestation makes perfect sense to me. I guess really my question then is, and you touched on this as well, how is the court to make that finding? What is that process?
On the attestation, under the way this bill is set up, it's much more like like an after hours relief from abuse. The judge has the paperwork. You leave open the possibility that a judge under subsection F, if there's something that the judge sees or the judge wants more, the judge has the discretion, if they have good cause shown and they do a written document as to additional information. If you had, for instance, a situation where the judge, somebody somehow gives the judge information in another party comes in and files something somehow and says, I want to intervene here. Well, the judge could say, okay, what's going on here? And maybe that might lead the judge to want to make additional requirements under subsection F that the judge now does as a matter of course in the adoption procedure. He or she doesn't have to do it. But there may be information the judge wants to get. But unless the judge goes down, we'll call it subsection F, and decides to get more, the paperwork is enough under this bill, and the judge has the ability to sign it on the papers.
Okay, I guess that's what I wanted to make sure about, because as we're talking about already knowing that things are handled differently, in some things are handled differently in some counties. I just didn't know how much this opens the door for a judge, to frequently ask for more information or to, that sort of thing where it's just.
Is that a potential? Yes. Is it a potential that if we came back, if we said, okay, next year, we want to hear from Ms. York, we want to hear from Mr. Hughes about what's it like in the courts and how is this being handled? Is it possible that there may be Mr. Hughes or Ms. York says, there's one judge who sees things a certain way? Yes, that is potentially possible. And the structure of this bill, unless you're going to say someone walks up to the clerk and hands the clerk paperwork and the clerk stamps it and gives them their adoption order, that is something which is necessarily at play. But we need to make sure that judges have education and judges have understanding as to a bill like this, what its intent is and what its implementation needs to look like from a consistency perspective for the courts.
Okay, so at a minimum, I think this is my last point or question. At a minimum, we should make sure that we're asking for the exact same things in the attestation and the findings as far as the language of whatever because as you said, there's an additional standard currently in the finding requirement. So we need to make sure that petitioners have had a chance to attest to that as well.
Yes, if you want the court to make findings and your ideal situation, as I understand it, is that the court should be able to make the findings from the filings by the petitioners. Whatever the court has to make for a finding would necessarily need to be included in the petition.
Are you good? Are you good? You sure?
I think so.
Okay, excellent. Ian.
I've got a statement and then two questions. And it's not really a statement, but I think I really appreciate what you said about going back to the judiciary based on the testimony we heard today. Just about kind of like what's happening right now. And the one other word that I'm thinking that I haven't heard from any of our is dignity. You know, like I think a lot about individuals who interact with the judicial system and like preserving their dignity as people. And in this particular bill, I think a lot about that because of how, you know, your parental rights and your parental status is like such a intimate part of your life. And so I would just hope that you bring that, and I know you know this already, but just I want that to be something that all of our judges are thinking about, especially when we're looking at a bill like this, is trying to protect that. Now much more technically. So for subsection F on page 3, line 11, I think the escape valve for the court to make more consideration is important, given that they could just make a decision on the filings. And I hear your concern about the in-person hearing part of this. How do you feel about the needing both to find good cause and for it to be a written finding? Is that language, how do you feel about that? And is it too much for the court to have to do if they have a concern?
Well, first, good cause is, we could sit around the table, I could give everyone a fact pattern and say, do you think there is good cause for X? And we may have a split. There may be different views. So good cause, the Supreme Court has defined what good cause can look like in certain circumstances, but it is a concept that is potentially one that brings with it potentially differing interpretations. So good cause, I think here would accomplish what I understand you're trying to accomplish, and that is, we don't want people to have to go through the process that they can currently go through now, because the entire goal of what this bill is to streamline it and not have them go through that. And I think it goes back to the word that you used, dignity. These are the parents. They shouldn't have to jump through these hoops, right? To go through this. And so I think having that good cause standard can serve to accomplish that. As far as written findings, there are times, and I testified in this committee, there are times that the judge should not have to make written findings. It should just be done on the record at a hearing. But here, that would put, if you will, the cart before the horse. If you have the language about an in-person hearing or appearance, you don't have that, you probably wouldn't be having a hearing. I would assume that remote is okay under this language. So unless you're having a hearing where the judge can say it on the record, there needs to be something written. And so I don't have an issue, even if you have a hearing. It's helpful if the judge after the hearing says, at the hearing today, the court, announced its decision and, made its finding. And even if the order said something as simple as the findings were on the record, to me, that is written findings. Mm-hmm. If I refer you back to the record, but at least there's a document that the parties can take home and look at and say, okay, here's what the judge said. And so I don't have a problem with that, with written findings. And frankly, what you're going to see happen is there's going to be a form.
Yeah. And
the form's going to say this matter came before the court, and then it's going to be check boxes. And the judge will check whichever, based on the evidence presented. A finding could be, based on the information provided to the court and the court's review of the files and records of the court finds that good cause is present for the following, and the court can just check the boxes. So long way of saying I'm okay with that. I think it helps us.
Yeah, great.
Do you have another question?
My last question is about, I don't know, I'm just looking at the 702 language from 15C that they kind of define donor, or not define, but donor as a non-parent, as a parent, it's not a parent from someone who's, donating. And then they define kind of how a donor would be a parent, but it says a person who provides a gamete or an embryo. It doesn't say a donor who provides. And so if it said donor, I would sort of agree that like donor feels ambiguous. But because of how it's written, I feel like how it's written, donor in where are we?
Page 3, line 7.
Page 3, line 7, thank you. If you went back to here and you just saw donors, a donor is not parent, is not a parent. I don't know if I see the same inconsistency you do, but
I understand that. In my mind, it went, you go from 702B.
Yeah. Yeah.
A person who provides is not a parent unless they have a written agreement.
Yep.
So a donor, as I see it, has the ability to say, I want to be, as part of a written agreement, I have the ability, that the donor has the ability to be a parent. Then you go to 704, and it talks about the written document. And the donor then has the ability to be determined to be a parent under 704.
Yeah.
And then they go jump back to 703, because they consented under 704, which is what it says, a person who consents to assisted reproduction with the intent to be a parent is a parent.
Yeah.
And so that's where I did it. Do I understand that there may be, I think the analysis you have is on target. I think you are hitting it right, but I also think that there's enough of a question that if you can add clarity to what do we really mean by this, because then let's get even better, we're confusing 708, the court can make orders.
Oh, yeah.
And so I don't know if any practitioners?
So yes, I have 3 hands.
I like that.
So we're gonna start with Kurt, then go to Meg, and then go to Michelle. And Michelle can
You're not
sum
gonna
up.
beat me by the time.
Go ahead,
I
Kurt.
think we probably all have the same thing to say.
I just wanted to point out the definition of donor in section 102 of 15C, which specifically excludes a parent under chapter 7. So that may even, that may be even more clear than the language in 702. I just wanted to point that out.
What was the site again?
So I can pop it up on Zoom if you want me to.
It's
Sure.
102A. 15C 102AB is the definition. Can I add to that?
Yes, go ahead,
Okay,
Meg.
so adding to that, while Michelle's pulling the definitions up, I think we have to, I mean, I really appreciate Judge Dunning that you identified this potential issue because we do really want to be clear about who can petition and who can't. And I think in our clarity, in working to be more clear on this, we don't want to inadvertently create a fog or a question about who is a donor and who is a parent. And one thing I think our Parentage Act does really well is clarifying that a donor is not a parent for a few reasons. One is the definition under 15C 102.8B that excludes parents under Chapter 7. And 2, like Rep. Goodnow commented, the really intentional word choice of person as opposed to donor under 15C 702 B1 and B2. And I think that that distinction in the word choice is really important because once we start conflating the idea of some donors might be parents, we get into a whole host of other problems of whose parental rights need to be terminated. Do they have parental rights? It creates a lot of confusion where we don't want to invite confusion. I think the language as written in 15C is very clear that a donor is not a parent. If we want to wordsmith page 3, line 7 through 10, like maybe we want to do that, but we don't want to imply that a donor, that there's a time in which a donor can be a parent.
I'll leave this to Michelle.
I will say, I confess, and I phoned a friend on this yesterday, a practitioner to say, hey, and I agree. I point this out with the comments, but we just took a few minutes to talk about how many statutes and jumping back and forth to say, here's why it's clear. And I suggest that if you have to go from several statutes in different chapters to say, here's why it's clear, it probably isn't quite as clear.
We can make it
For 14 probate judges.
Right.
Yeah, so
That's what I-
Michelle will make it. clear.
And that's why I raised this, because as I said to Mr. Goodnow, Rep. Goodnow, I agree. But to get there, there's a few hurdles and the logic you go through. I just think if you have the chance here to just say, boom, here's what it is, we minimize the risk that, as Mr. Hughes talks about, he's spending X amount of time trying to convince a certain judge, who I don't know who it is, by the way, that the law says something plain and unambiguous.
Yeah.
And so I want to minimize that. And so if there's a way to do that, I would suggest that.
And Michelle has it for us, I'm sure, so, but when we can,
Those are my comments.
excellent, so I appreciate, any other questions for Judge Zone?
Can I ask?
Yes,
just to go back
please,
on
please,
something?
yes,
So this goes to the issue of the competing claims. I get what you're saying. I think, the choice of terminology is because the parentage title talks about how to adjudicate competing claims and uses that terminology. And I just wanted you to kind of repeat kind of your idea and suggestion around what do you think is doable for the court, considering the limited information that the court gets? And then I was wondering if then the other witnesses could kind of chime in on that.
So is this a kind of a getting into and drafting the
Yeah,
language
do you
type
not want me to do
thing?
that here?
Well, yeah, maybe it makes more sense for you to work with,
Okay.
with
Sure,
the advocates and Judge Zone to work that language out rather than trying to draft in here. Does that
sure.
make sense?
Yeah, no, I just wanted to get people's input, but I
I
can
was
do that on
excited
email.
for that.
I suspect that the attorneys and advocates here would be able to say, okay, we have some language that we think would work there.
Right, yeah,
We take a look at.
yeah, rather than doing the drafting right here, so, although I would like that as well, but they have other things. So just a quick, an overall question for any of the witnesses, including Michelle. Is there anybody who would object to this bill that we should be reaching out to have come in to testify? Because we'd like to hear all sides.
I will say that I did survey the probate judges, and a number of them did respond to me. The response was favorable for this type of bill. I did hear from one probate judge who had concerns about a number of aspects of this, but I would note that there were issues that you've already talked about, that why do we need this? We already have the birth orders under 708 and other areas. There was also concerns about due process, that if you don't, the language of who is a parent and who is going to be notified, and we can't enter these orders unless we know that everyone who is a parent or has a parental right, they are notified of what's going on. And so,
Who raised that?
I wanted to make it clear that there was not unanimity in favor of it, but that I think that the points I made today, I tried to incorporate any of those types of concerns for your consideration going forward.
So, Meg, anybody out there that you can point to who would be objecting that we need to hear from?
I've been trying to think after you asked that question, because these, and maybe Polly also, Kirk has some ideas about that as well. I think that these bills are wildly popular. I think that the states that have enacted them, many states have, they streamline the process and they are really clear. We're not expanding the law. So as far as pushback goes, we're not saying we're going to start treating more people as parents than we already treat as parents. And so if anything, this is just really shoring up protections. There might be some people who have questions about why those protections are needed when Vermont already recognizes these individuals as parents. And so maybe some explanation and education there would be useful. And as far as the notice requirements go, we always have situations where we might not know what we don't know, right? And even in the parentage judgments under Article 7, under the Parentage Act, you have the parents saying, hey, there's nobody else out here who could be a parent. So you have people attesting to that also. So I think, I struggle to think about who would come up and say that this would be problematic. But if I think of anybody, I'll let you know.
Fair enough, yeah, Michelle.
And I would just say in the past, when we've worked on the parentage issues, we've worked really closely with OCS and at times with DCF, but I think that this is different because parentage is already established. The others are different because you're trying to establish parentage for the purpose of, you know, doing child support or something like that. But this is a different case where it's, you know, it's confirmation of parentage rather than the establishment. So I think, you know, normally I want to pull in as many people as possible because I'm not the one out there in the field doing it. But I don't think you need to, those agencies in this circumstance.
I appreciate that. Kurt, anything you want to weigh in on that question?
Not on that question. I haven't heard of any negative responses to it. You know, it's just it's only positive from what I can see, and just I appreciate Judge Zone weighing in on the definition of donor, because the more we can spell things out. Like in subsection A, you've already imported definitions from Title 15C. And I think, you know, we can talk with Michelle about it, about importing the definition of donor into that section as well. Especially since it's in a different title. You know, I agree with Judge Zone that it would be good to clarify that. And since the whole point of this is to make things easier for folks and for the courts, any clarity that we can add would be terrific. But no, I have not heard anyone that would be opposed to this bill.
Okay, I appreciate that. All right. Well, thank you, Judge Zone. Committee, I guess, couple questions for I did suggest earlier having an overview of the whole parentage law. I don't know if we still need that given the conversations we've had since then, but I'm happy to ask Michelle to do that. And I'm mainly looking at the three new folks because I think the rest of us have had exposure to the parentage law over the last biennium and biennium before. Do you think we need that?
I'm pretty familiar with it, actually.
I'm okay, Mark.
Okay, thank you. So the second question is whether we want to put surrogacy in there. If we want to put, well,
You have to write it.
I didn't ask the attorney. I heard some of his questions. He got into a depth of, and he has the statute right in front of him. You can read it. Ian, are you good?
That's fine. Sorry.
Yeah, I didn't mean to point to you. So where are folks with adding surrogacy, or are we comfortable with where we are with surrogacy?
I'm comfortable not.
Not adding it. I mean, I'm either way, but I guess you raised it, and so.
I'm either way too. I mean, it seems like the protections are there.
Right.
It doesn't seem like it's necessary to augment the bill as is.
Anybody have a different view on that? Are you good with that?
Yeah, good.
All right, so you'll just have Michelle work on the various language with the folks, and if at all possible, I'd love to schedule you for tomorrow afternoon to go over that. Is that going to give you the time?
Probably.
Well, if not, then we can always adjust. We're very
Just wanna
flexible.
Make sure I have time to draft, send it out to folks, get comments.
Right.
Ask them to get it back to you promptly.
Hear you say that? Yeah. Or he's keeping his judge face on.
We're within an hour.
All right, so just one other heads up for folks. Not sure, we at some point, we're going to try to get 41 back on the agenda, whether it's today or tomorrow, I'm not sure. And after the floor, it looks like the floor is going to be short today, and because we're getting out early yet again. I've asked Ann Donahue to come in and go over H21, just introduce us to the bill, and we can then all decide whether we want to proceed with that bill or not. But so we're going to have that bill introduction right after the floor. All right.
Yeah.
So we'll